So when we're thinking about content moderation, of course, the thing that is most difficult to deal with is what I'd call the category of lawful but awful content. We all are familiar with the fact that under Supreme Court guidance, marching in favor of Nazis is permitted. You can go online on First Amendment principles at least, or go out in the street with a sandwich board and proclaim for Adolf Hitler till the cows come home, and the First Amendment's going to protect you even though you've offended all your neighbors. That's the most difficult aspect of content moderation. The First Amendment is fairly straightforward, and it says Congress shall make no law. And then, as a result of court interpretation, that prohibition has been extended to the states. So we read it to say states shall make no law. That's not ambiguous, that's very straightforward. And as a result, lawmakers have difficulty doing anything at all to abridge the First Amendment rights of platforms. When they are doing content moderation, exercising editorial discretion, the courts have held that they are exercising their First Amendment rights. We, as users, don't have First Amendment claims against private platforms because they are not the government, and it is the government that's restricted under the First Amendment. There has to be what's called state action. There's private action when content moderators take something down, and if we think that they were wrong and they shouldn't have done so, the trouble that we're going to have if we sue them for that is that they are going to claim protection by the First Amendment, and they will, in that legal sense, be correct. So there's a very important distinction to be made between what the First Amendment does and what Section 230 does, and I'm afraid a lot of that is lost in the broader discussion in the country. Section 230 is attributed the things that the First Amendment is really responsible for, and that is the kinds of content moderation that platforms do. Section 230 is not the source of platforms' right to take things down or to discriminate. For certain, it's not the source of platforms discriminating on the basis of political predilection, political favoritism. The First Amendment is, in the same way that the First Amendment protects everybody's right to express this political view and not that political view. Platforms have that right too. So what does Section 230 do? Section 230 makes sure that platforms at least would be willing, legally, they would not be disadvantaged to host our content and to do so these days for free. That's what we get out of Section 230. So while people of all political stripes might want to complain about some content moderation that they disagree with, you have to compare where we stand right now to where we would otherwise be, and where we would otherwise be is, again, knocking on the door saying, please print my letter to the editor, or please run my op-ed, and there are only so many pages in the newspaper and only so many hours in the day on television or on radio for that to happen, and most of the time the answer is going to be, sorry, we don't have room, there's no room in the inn. 230 makes sure that from a liability standpoint, there is not a disincentive for platforms to host as much user content creation as they possibly can. That's the ideal.